Good morning, everyone. Welcome to the Thursday, May 21st, 2021 agenda meeting of the Minnesota Public Utilities Commission. I'm Katie Sieben, the chair of the commission. It doesn't sound like the microphone's working. Can you hear in the back? No? 1 second, please. Is that better? Yeah. Okay. Thank you, Mary. So good morning, everyone. Again, today is Thursday, May 21st, 2026. This is an agenda meeting of the Minnesota Public Utilities Commission. I'm Katie Sieben, the chair of the commission. I'll take the role of the other commissioners who are present, and then I'm going to turn over the gavel to Commissioner Sullivan, who's going to chair the meeting today. But Commissioner Partridge.
Here.
Commissioner Sullivan.
Here.
And Commissioner Tuma.
Here.
And I'm handing over the gavel to Commissioner Sullivan with the understanding that we are going to conclude this morning's hearing by noon. Right, Commissioner Sullivan? Hopefully.
We'll see. All right. Thank you, Chair Sieben. We have two items on the agenda for today. The first item, if staff will introduce the matter, and then if folks here are going to be testifying on this or will be asked questions, if you could come forward. But I will hand it over to...
That would be Mr. Runke and Ms. Bump. If they could make sure they could make their way up here, there'll be questions.
All right. Floor is yours.
Good morning, Chair and Commissioners. Item number 1 is docket number E002/ESS-25-319. In the matter of the application of Northern States Power Company doing business as Xcel Energy for a site permit for the up to 600 megawatt Sherco South and West Battery Energy Storage Project in Sherburne County, Minnesota. The questions before the Commission are: should the Commission grant a site permit for the proposed project? If granted, what additional conditions or requirements should be included in the site permit? And should the Commission approve and adopt the applicant's proposed findings of fact and conclusions for the project as amended by staff? I have no further remarks, but I am available for questions. Thank you.
Thank you, Ms. Maxon. All right, if we'll just start, if the parties could introduce themselves, and we will start first with Ms. Johnson.
Good morning, Chair and Commissioners. My name is Emily Johnson. I am an Environmental Review Manager with EIP Unit here at the Commission.
Mr. Runke.
Good morning, Chair and Commissioners. I'm Nate Runke with Local 49 of the International Union of Operating Engineers.
Good morning, Commission. Samantha Bump with the Minnesota DNR.
Good morning, Commissioners. Christy Brucevan from Frederickson and Byron, appearing on behalf of the applicant, Northern States Power Company, doing business as Xcel Energy.
Good morning, Jordan Clitty with Xcel Energy.
Good morning. Tyler Beamer representing Xcel Energy.
All right, thank you. Now we can turn, we are not planning on opening statements, so we'll turn first to Commissioner questions. I'm going to look to my left because I know to my right somebody does have a question or 10. Question.
I just was hoping, thank you, Chair Sullivan, could we first hear from the applicant about, since this is one of the first larger BESS projects in the state, could you give us an overview of the highlights and what you're hoping, when the estimated construction date is too?
Actually, before we do that, I see that the mayor of Becker is also on. He's on. If you could just, Mr. Kolbinger, if you could, Mayor Kolbinger, if you could just turn, if you're, we may have questions for you, but there you are. I just wanted to recognize that you're on, and thank you for being here, Mr. Mayor.
Thank you, Mr. Chair and Commissioners.
All right, Ms. Bruceman.
Thank you, Chair Sullivan and Commissioners. So As you noted, this is a 600 megawatt battery energy storage project in the city of Becker. It's part of a obviously much larger facility that's and build out here at the Sherco plant and in that surrounding area, and really an important part of the transition that Xcel Energy has been implementing in this area. The project is actually two smaller projects in other cases before this commission in terms of how it came before you from a resource perspective, but because it's sited on the same site, you have the 600 megawatts here together in a single site permit application. And the company's plan is to begin construction this summer. So as soon as we get an order and can get our compliance filings in, construction will begin.
Thank you. All right, okay. Commissioner Tuma.
Well, yeah, thank you. And that's, Chair Siebman, that's a good start because this is an important project. I wanted to touch on that first before we get going. This is one of our first 216I permits. I think it'd be the first large battery storage under 216I. So we're not talking about a 15 mile, 115 kV line here. This is a major project. Over $1 billion, 600 megawatts of storage, 2,400 megawatt hours in the system. This is a critical link to our overall system that we are working on. Xcel has been developing around several projects, and so it's exciting to be working with the city of Becker. Mayor, I'll have a question for you down the road, but thank you for being here. We do view Becker and your staff has been absolutely fabulous over the years to work with, and so you got a good team there, and we appreciate the partnership we have. And I'll touch base on a couple questions when we get to it, but I didn't want to miss this opportunity to point out that our staff did a great job and nominate them for future stars of the team because they got this done in 5 months. The statutory requirement was 6 months, and so this is a huge project. There's a few things that we need to tie up, but that's always what happens at this stage to make sure we got it all set up so that it's teed up to get to that pre-construction and pre-operation meetings with everybody understanding what the process is. But I just wanted to point out that 5 months on a 6 month process, and this is not a small project by any means. It is huge. And so, and thank you for the applicant. It doesn't succeed unless the applicant has reached out and done work in advance. And so thank you for your hard work. So just let's tie up a few loose ends. I called up Miss Bump. I didn't see you at first, but you're figuring out how to hide from me now. So it's smart of you. So the tree language, let's start with that, 5.4 and 5.7. We've obviously, we've read through the brief, so we understand what's going on. So there's 2 additions that my understanding have been talked about, have been assessed, looked at, but we have now some final language that now is appearing in the permit. I would assume, Ms. Bump, you've seen that language. And my question to you is, does that work for the DNR?
Ms. Bump.
Chair and Commissioner Tuma, we prefer that they coordinate with us, and if the timing is not feasible, that way we can work with them on it. Given the location of the process and the proximity to the Mississippi, we're highly interested in the timing of tree removal here.
And it seems like we took out the actual time that we had in our other permits and basically said, you need to work this out with you. So timing, you're going to go there, make an assessment, and do the work. And so it seems like that was what our staff was trying to accomplish with the tree clearing language in 5.4. And so I just want to make sure the language, as you see in blue on page 14 of the permit, is now satisfactory, still satisfactory to you. They're trying to accommodate, the timing and make sure everybody had a chance to be communicating, but that we weren't going to specifically put a hard date in the permit.
Ms. Bump.
1 second as I pull up the exact language, please. Chair, Commissioner Tuma, the language with coordinating with U.S. Fish and Wildlife Service and us, we feel it would be ideal to coordinate with us first And if we are unable to meet their needs, then they coordinate with U.S. Fish and Wildlife Service in this case. We feel like we would provide some very detailed coordination.
It seems like that as a permittee shall coordinate with the DNR. So, Ms. Brusman, my assumption is, first of all, you okay with the language? And second of all, are you planning on coordinating with them? Because we want to make sure we have flexibility, but we also want to be killing long-eared bats if they're there. So,
Ms. Brusman.
Chair Sullivan and Commissioner Tuma, yes, and in fact, Mr. Beamer's already had with DNR around this, and it certainly would be our intent to continue those coordination efforts.
Can you hear as well as a bat? Is that what's going on? Because I can't hear anything.
a long-eared bat?
I feel like a dog who can hear like the whistle that no one else can hear right now. I'm so sorry. There's just.
No.
I can. Okay. I got confirmation someone else can hear this too. I can tell Samantha Bum can. Yeah. Okay.
Old man here can't, but that's okay.
Okay.
Let's give it another try, Ms. Brusman.
Okay, so it's certainly our intent to continue to coordinate with the DNR. We appreciate staff's recommended language here with the flexibility to remove the dates, because again, if we believe that based on the habitat and the trees in the area, that we don't actually have really good quality bat habitat. We understand the DNR also has some concerns around avian species, so that ongoing coordination makes sense to us, and then hopefully gives us some flexibility to pick up some of these summer weeks of construction. And again, the dates that were in there were August 15th. That was the end date. So we really are talking about a couple of weeks, but we think this coordination language is a helpful and useful compromise, and we're in support of the language that staff's recommended.
So if their experts come out and say to you, look, we do note there are bat nests in here, we need to avoid construction in this area for a little bit, the applicant is fine with that.
Chair Sullivan and Commissioner Tuma, yes, we have thought about how construction, if necessary, to avoid particular areas. Again, we're hopeful that's not necessary, that we can just make a construction in whole, but this coordination will allow us to have those more detailed conversations.
You're already talking to them about fencing. I know that is going on. We need to keep the deer out of here. This is not it's not a solar facility. This is a very highly charged area, and so you'll be working with them on fence placement and everything like that. So there's going to be significant coordination because you are right next to the Mississippi and the Mississippi watershed and flyway. So, and I'm seeing a lot of heads shaking. So go ahead.
Thank you, Commissioner. Yes, we've already worked with Martin Donovan, and the standard height for Xcel battery energy storage is 10 feet, which is sufficient for DNR purposes to deter deer from jumping over. So there's no further fence design criteria in coordination with DNR. They're signed off.
The other thing is sorry.
Oh, it looked like you were going to say, you were wanting to say something.
Chair and Commissioner Sullivan, our fencing design has been going, our coordination on that has been going well. Back to the tree removal timing, we are very willing to coordinate with them, but we will probably still be very adamant to stick to those dates. So if you can take the dates out, but we will probably still insist on that.
Good to know. Ms. Brusman, anything you need to add? I'm satisfied with the language the way it is, and we think it allows for the coordination, and obviously you'll have conversations and plan and profiling and that with the DNR, so we can work through that if there's any disputes. We hope there's not.
Chair Sullivan, Commissioner Tuma, yes, and we hope the DNR is open to being flexible here in terms of how we define starting construction, and certainly do want to make sure we're protective of the species, but also meet the project schedule. But again, we're supportive of this language, and we'll continue those coordination efforts.
For the record, you have consultants that are working on this, examine this area, understand what's going on there, and so they're professionals. They'll be working with the DNR on a professional level. So this is not, a bunch of developers saying we must do this. You're working with a team that's making sure it's being done right too. So,
Chair Sullivan and Commissioner Tuma, that's correct.
Next, Ms. Brusman, Appendix D is the route permit. There was a lot of Appendix A and B, which is like the language changes. Everything seemed to be fine to me, but I wanted to make sure I'm asking you, as Appendix D sits now with these changes that we just talked about, does that satisfy the permittee?
Ms. Brusman.
Chair Sullivan and Commissioner Tuma, it does, and we appreciate staff's work on the findings of fact. Again, this is one of the first 216I permits, certainly the first best, and so there are some tweaks to that language. We appreciate their detailed read on it and are in agreement with both the permit language and the proposed findings.
Excellent. Good work, guys. Mayor Kolbinger, is that how you say it, Kolbinger? Am I getting?
That is correct, sir.
Well, welcome. I think this is the first time you've been in front of us. Like I said, we've been very appreciative of our partnership with Becker, so I'm glad to see you here. So thank you for showing up for your community. And one of the things I just want to make sure you knew, because it's your first time, the way the commission does its permits, probably a little different than the city. When you do your permits, you're doing a lot of inspection, looking at it. We do view our partnership with you as one of our eyes and ears on the ground. We don't have an inspection team going out there and making sure things are happening. And so we drafted this permit with that in mind. And you indicated earlier about emergency services, which is hugely critical for these new facilities, these battery facilities. And we've been having these conversations with our developers and our local units of government to make sure that the permit is coordinating between you. And so the way the permit is designed on paragraph 8.11 is to have the developer here, Xcel, work and coordinate with your local emergency responders to develop a plan. These are not places where you just run in and start spraying water over things. Okay, people die if that happens. And so we want to make sure there is a coordinated plan, and they must have that 14 days before the pre-construction meeting. And then you have a chance to look at that and make recommendations. You should have already been making recommendations by that time, but if you don't feel it's up to snuff, you have, prior to the pre-operation meeting, a chance to try to work that out. And if it doesn't, it could come back to us if it's not coming out the way you think is satisfactory. And it includes the acquisition of additional equipment that may be needed. And so I know that you made comments earlier in the process wanting to make sure that this is covered. That's how the permit deals with it. I just want to double check to make sure that you find that language sufficient.
Mr. Mayor.
Thank you, Chair Sullivan, Commissioner Tuma. Yes, thank you for those comments. I not only serve as the mayor of Becker, but I'm also the chair of our Joint Powers Fire Board. So that is our fire department is a co-sponsored department between us and the township. So we've had discussions at our Joint Powers meetings, and I want to commend Mr. Quiddy and Mr. Beamer from Xcel Energy. They've been very good about listening to our comments. We've had discussions, and we do already have some training plans coming up here soon, not only with our department, but we're going to invite any departments who could participate in mutual aid with us. So we are prepared and have the experience, and definitely nothing is more important to us than the safety of our first responders. So we're looking forward to the partnership, and we're very comfortable with where things are at right now.
Excellent to hear. That's exactly what we want to hear. So thank you. And our staff will keep an eye on that as it comes through, and making sure that if there's any feedback that you may have, we're incorporating that into our discussions at pre-construction and pre-operation. Mr. Runke, you did comment back in January on it. Want to make sure that we are paying attention to local contractors. And like I said, this is not a small project. Could be up to $1 billion of cost. And so we want to make sure it is local labor. We have two provisions in the permit, 8.5 and 8.6. One is the standard reporting language that we've had and worked on for a number of years, and we appreciate the assistance that you've had in putting that language together. And then we also have 8.6, which is prevailing wage. And so I just wanted to just double check with you, because I didn't see any other comments later on in the record, but just to make sure that you're feeling comfortable with where the permit is sitting right now and this project as it's going forward.
Mr. Runke.
Chair and Commissioner Tuma, yes, we're very comfortable with the project. actually, I put in a second comment just to make sure I wasn't getting in the way of the expedited process here. We'd love to see that you guys are working that way. The whole larger project up at Sherco has been an amazing opportunity for tradespeople. I know our trade for sure I can speak for, and I assume most of the any other trade that was up there would say so, and we look forward to a project like this if it gets permitted, doing more for that for the tradespeople that'll work on it.
Ms. Maxim, Ms. Johnson, am I missing anything?
No, I think we're good.
I have no further questions. I have a motion when you're ready, Mr. Chair. But if others have questions, I don't want to.
I think we're ready for a motion. We got to slow this down so that we're past 11.
Talk real slow if you want me to.
Ready for your motion.
My motion would be staff recommendation. That'd be decision option 1, 2, A, and B, and 4 and 5.
All right, is there any discussion on the motion? All right, before we do vote, I do want to thank you, Commissioner Toomer, for digging in. I think this is an important project. 600 megawatts of storage that's very significant, and I think it's really important for what you're doing at the Becker host community. As most people know, Becker's been a host community for our largest power plant in the state for decades, and I think Xcel has shown, and the Minnesota process has shown, how we continue to support our host communities. And I think it's a really critical, important place on the electric grid, and I appreciate all the work that you've done on that. I also hope that since DPT is here, that they have heard that Minnesota's new permitting legislation is saving time. And I think that is very important. So
There's a new story.
there's a news story. So with that, we can move to a vote. All in favor, please say aye.
Aye.
Opposed? Motion passes. Thank you. All right, we will now move on to our second item of the day. Mr. Fournier will introduce the matter. And then after Mr. Fournier introduces the matter, I would like to make a quick statement, and then we may have a discussion before we get to the matter at hand.
Morning, Chair Sullivan and Commissioners. Item number 2 is docket number 26113, involving Renville Sibley Cooperative Power Association in the matter of a formal complaint by Rauenhorst against Renville Sibley Cooperative Power Association. Questions before the Commission.
Is Mr. Fournier, is
Is your microphone on?
mic working?
It's on. Thought it was. Oh, like that? Okay.
Could folks hear that, though? Do we have to?
We have to do it again?
Let's just do it over just to be sure.
Again from the top, okay.
We want to make you do a little extra
I
work.
got practice. No, I got
A little
should be
practice in.
perfect now.
You got a lot of learning to do.
Yeah, that's right. Yeah. Learn every day. Good morning, Chair Sullivan and Commissioners. Item number 2 is docket number 26113, involving Renville Sibley Power Cooperative Association in the matter of a formal complaint by Larry Rauenhorst against Renville Sibley Cooperative Power Association. Questions before the Commission are: does the Commission have jurisdiction over the subject matter of the complaint? Are there reasonable grounds for the Commission to investigate these allegations? Is it in the public interest for the Commission to investigate these allegations? If the Commission chooses to investigate the complaint, what procedures should be used to do so? Are there other concerns related to this matter? Since the briefing document was published, 3 documents have been filed in this proceeding. Additional decision options filed by Larry Rauenhorst on May 18th. Preferred decision options filed by Cure on May 19th. Decision recommendations by Clear on May 19th. Mr. Chair, the parties are available for questions. Thank
All right, thank you, Mr. Fournier. Before we start, I do want to just quickly disclose that in 2013, I did work on the legislation that that helped, that put in place this statute. I do not, however, think that that creates a conflict of interest on my behalf. I don't, I can be impartial on this matter, but I do want to disclose it. I want to make sure that parties are aware that I did work on this legislation, but I do not think it affects my judgment in any way. That being said, if a party objects, you can feel free to object and we can quickly discuss the matter, but I just want to make sure that folks are aware of that. So when you introduce yourself, I'm going to start with the Attorney General, and then we can move Department of Commerce, sorry. We can start with the Department of Commerce and move from my left to right.
Anne Marie Curtin with the Minnesota Department of Commerce.
Sir? If you could introduce yourself. Can you, Mr. Rauenhorst, if you could just speak into the microphone so we can hear. Can you introduce yourself again so we can all hear it and pick it up? Okay.
I'm Larry Rauenhorst's brother, Raleigh Rauenhorst.
Okay, thank you for being here.
I'm the Minnesota State Director for Solar United Neighbors.
Great, thank you.
Good morning, Zach Alter.
All right, thank you. All right, with that, let's move directly to Commissioner questions. Are there Commissioner questions? Commissioner Partridge.
Thank you, Chair Sullivan. And thank you to the parties for being here. I think this is an important topic that we've heard is an issue for many folks and co-ops as they figure out how these rules work and how to implement this statute. From my perspective, I think that staff really created a clear record here that we as a commission are not, typically we do not take up disputes about a rate. We take up disputes about a service issue. We have taken on a dispute in a docket recently that was related to a co-op who threatened to disconnect a customer, and that was very clearly a service issue. This legislation puts the onus on the customer and the co-op to work out rate disputes related to net metering. And in my opinion, while this may have merit through the district court system, I don't think that it is within our jurisdiction to determine this complaint. In my opinion, Mr. Rauenhorst, you and your attorney have done the right thing, which is to pursue this complaint in district court, and then you can carry on and continue that complaint through that process, and the judge will determine the merits and make a decision. In my opinion, it wouldn't be within our jurisdiction, and it isn't our place to weigh in on the substance of this matter. That is my reading of this, but I'm also very open and interested in my fellow commissioners' opinions.
Commissioner Sieben.
Thank you, Chair Sullivan and Commissioners Partridge. I largely agree with the rationale that you just stated. I think that there is a significant issue here to be resolved, but in my reading of the record, it's not for the commission to investigate and determine the best next steps. I particularly appreciated the Department of Commerce's legal analysis, and am supportive of their reading of the law and how the commission should move forward with this complaint, which I think echoes what Commissioner Partridge said, which is to find we don't have jurisdiction over the matter.
Commissioner Tuma.
I just have a question, Mr. Alter. Reading through the record, and actually went back to 2013, 2015, and 2017. had a very significant hearing after the legislature adopted Subdivision 11, making your client essentially the commission, which is, we are a creature of the legislature. The legislature created us. They give us jurisdiction. And so I found it a challenge to work back then through the legislation because there was a lot of overlapping timing issues. But one of the questions I had back in 2017 was, after we were done doing our work under Subdivision 11, if you remember the statute says we were to continue our investigation and must end it by the end of 2017 and make any recommendations we had to the cooperatives to be able to comply with the law. And I felt like we did do that. We told you had to use class cost of service studies that were relevant to the class of customers that you were dealing with. You couldn't just use a residential class cost of service study, which is what MERA was proposing at the time. You were not a member of that docket or part of that. Your client wasn't, I should say. And so my question to them at that stage was, well, what happens after 2018, January 1, 2018, when a new cooperative comes in, what is the expectation? And it seemed like, and my question was, does it come back to us if they don't do a class cost of service study, or, which is, again, to set rates? And the comment back, and Mencia was there, the advocates for to do more, and said more of this DG, or more of this effort, were all there, and no one said it comes back to us. It is you and your members with your board, who is elected by the members of that cooperative, who must establish this. And so it seems like, as far as this is, if it is just a rate dispute, we have no jurisdiction according to Subdivision 11. That it is your board that makes that decision, and you are now the commission for all practical purposes. Makes a complicated jurisdictional question. I feel sorry for the district court judge who has to hear you guys make this argument. But correct me if I'm wrong. Right now, your client sits in the place of the commission as it comes to a question of whether these are appropriate charges and rates as it relates to these type of systems.
Mr. Alter.
Thank you, Mr. Commissioner. The answer is yes. I think that the legislative history in 2017 is what it is. The provision that matters, I think, with this question is Subdivision 8, Subdivision 11. And that provision, based on it, is that a cooperative like Renville Sibley adopts the required steps into the shoes of the commission, and it's self-governing board. So when they register, it's not an issue. The result today is that business should not.
And there's times when our masters tell us to do stuff that I just think are crazy, and I have to do them anyways because the legislature says you must make these determinations. I may put myself in the shoes of that legislator and say, you really shouldn't have given this to us, or you should not have taken this away. Actually, in this situation, I agree with you, because your board is just as smart as we are as far as to figure out how to do a rate, okay? We don't need to explain that to you. You have members, they come to you, they complain. I'm in no better position than your board is to make that determination. So I actually kind of agree with what the legislature did here, but I have to apply the law, and I want to make sure I'm applying the law correctly. In the way I see the law as I sit here today, when it comes to a rate dispute, it doesn't come to me. And I want to make sure, before I ask the complainant why they think I should take it up, to make sure that it is a rate dispute, okay? My understanding of the record is you had a contract you started to work out with these folks as far as interconnecting to them. And they replied on a form, and they filled it out and saying, we want the higher rate, the applicable rate for what would be the avoided cost for a residential customer, is the way I understood it. as opposed to the avoided cost, what you would normally pay from your provider GRE for this. And that when it came back, you said, well, wait a minute, that's not the rate we agreed to. And as of now, no service has been taken, but I want to make sure that if they came back and said to you, we're okay with that rate, the rate that your board has worked on and did, you would sign a contract with them and you would take their power. Regardless of whether there's a meter out there or not, you would have worked on with them to take their power. Is that my understanding?
I'm sorry, I think I missed the last part of your question. The microphone.
I would be careful. This is an important part. In other words, they came to you and they said, we don't have service out in this open field. We want to put solar panels out there and we want you to take the power. And now it became a dispute about rate, okay? They sent back a form saying we want this higher rate. But now if they were to say to you, we are going to take the rate that was set by the cooperative, you would have taken their power.
We're having some challenges with folks on the WebEx hearing.
That's
the
not
particip-
anything with us.
But yeah, could folks just speak very clearly into the microphones?
And Chair Sullivan, Mr. Alter, can you just confirm that your mic is on? Does it have a green light? Okay. And just speak really closely to it so that people online can hear.
Testing, 1, 2.
Okay.
Okay, we're good.
So answer the question. In other words, if they were offered to take power, give you power at the avoided cost, you would have worked to connect them to the system. Is that my understanding?
Mr. Commissioner, yes. The answer is yes.
And then my understanding, your board established a mediation process to work with these individuals if there was a dispute on the price or anything relating to the interconnection. And is that still available to this potential customer?
Mr. Alter.
Mr. Commissioner, yes. Renville Sibley has always been open to mediation in this dispute. And even as recently as this week, we've sent communications to opposing counsel making that position clear.
So I'm sitting here, I hope you understand, we want to take everybody's concerns seriously, but we are creatures of the statute. We are here to operate under the law. And as I see the law right now is, if this is a price dispute, not a service dispute, okay, I not have any jurisdiction at all. That's what the legislature specifically was telling us in 2017. I know, Mr. King, you're ready to get it. We'll give you a chance. And good to see you, by the way. It's been a while, so sorry.
Mr. Rauenhorst.
Can I read a short opening statement?
You can do whatever you want to answer my question, but it's about whether we have jurisdiction is what I want to hear. So,
Well, good morning, Chair and Commissioners. Thank you for allowing me to say a few words on behalf of my brother Larry regarding this matter. I'm speaking for Larry because his health is declining and dealing with this matter has been a challenge for him. It's unfortunate that while we should be focusing on his health, he is instead trying to move his agrivoltaic project with the U of M forward. We are both engineers, and our whole lives we have tried to improve things around us. It's in our blood. So when the opportunity to work with the U of M to try to figure out how to improve agrivoltaics, which is incorporating solar energy production with agricultural production, presented itself, we were excited to try to figure out a way to make this work for the type of farming that happens mostly in Minnesota. Row crops like corn and soybeans are the most prevalent. And to be clear, we are not just trying to generate electricity in an empty field. It is a farm field. Like most farm fields, it is an integral part of farming business, and it is filled with crops for part of the year. So we are trying to generate electricity to power the small climate-controlled data collection center that we constructed on site. We established service, as well as powering the electric tractor that's used to plant the crop and other robotic electric powered equipment to weed and grow raise those corn and soybeans. The U of M has weather and soil moisture monitoring equipment at the site. We're also exploring the U of M, with the U of M, whether we can produce fertilizer on site. This would use most, if not all, of the electricity the solar panels would generate. This is especially important if you consider the crisis that farmers are experiencing with the cost of fuel and fertilizer these days. So any statements that there is no load at this site are simply not true.
But are you receiving service at the site?
We are receiving service at this time
From Renville?
from Renville Sibley. That's our only option. There is no other option available.
I know, and that's the part of the process that we're trying to understand. What is our role at the state commission in this? And so your project, by the way, I've watched the shows and I watched the coverage. I've read it in the paper. I've read the record very closely. Okay, it's a fabulous project. This commission would welcome this. If someone came to us and said, we have kind of a pilot project, and Xcel Energy wants to fund this pilot project to figure out if it's affordable. And if we had jurisdiction given to us by the legislature, I'd be 100% for it. But
So
the
this
question
is-
I have is
the
price.
We have to go through the chair,
Yep.
and we're not going to interrupt each other,
Sure.
either side. So let's just, everybody say their question, answer, and then we move on.
Yes, my apologies.
This is not a rate issue. We do not disagree on the rate. Renville Sibley Co-op's policies establish the proper rate. It's in their, it's on their website, it's published. For a qualifying facility, they pay the average retail rate. How can they go against their own policies? Furthermore, they've introduced into their rules and their bylaws mandatory arbitration, which they threaten to prevent us from going to district court because of mandatory arbitration, where we would bear 50% of the cost. They've also implemented rules that are in direct violation of the rules that allow them to be self-regulated, such as this 1 mile test, where if you have 2 facilities within a mile of each other, they're not going to allow that. That is in direct violation of statute governing net metering. All that we've asked for over the last 2 years is that Renville Sibley Co-op simply comply with the clear language of the law for net metering. No one disputes that Renville is refusing to pay the net metered rate for a solar system that is less than 40 kilowatts. And it's a qualifying facility. There is now an existing service there. We're using electricity. We may not use all of it every month of the year. My brother and I have invested our own time and money into this project with anticipation of offsetting some of that cost with that net metering. And it's clear on their website and in the legislature's law that's laid out. So if the PUC is not willing or able to tell Renville Sibley Co-op to comply with the law, can you at least tell us what state agency is supposed to make sure co-ops comply with the law? We just want to know who is supposed to make sure that co-ops comply with the law when they refuse to do so.
So just tracking, I mean, I understand what you're saying. Again, we think the project is perfectly fine. I would be 100% supportive of it if an IOU came in here, an investor-owned utility, and said, we have a pilot project to work with the U of M to do this, to figure out if it's cost-effective. I would expend extra ratepayer money to do that. But the legislature, I think, has been made very clear to us in 2017 that these decisions are met for by an elected board of your membership board, okay, that you're a member of. And if they violate that, then you go to district court, which is my understanding you did. And so I don't know where my jurisdiction starts here. And I think, to me, it's very clear that this looks more like a rate than someone trying to discontinue service for a customer who has behind the meter activity going on at their sovereign nation. Okay, to me, they're not even. It's not even a close comparison. And so, as I sit here today, I think the legislature has told me I don't have jurisdiction and I don't have an obligation to try to figure that out. That's the legislature's responsibility. And if you're not satisfied with it, you have legal recourse in the court. My understanding, Renville would agree with that. And when we had discussions back in 2017 to do this law, the question came up, what was the jurisdiction? And it was district court. And so I'm trying to understand where we have jurisdiction, because I have a look at the statute, and the statute seems to be very clear that Minnesota has set up a system by which the elected board that you go to is responsible for your rates, and we shouldn't interfere it, unless, of course, they opt in, which they haven't. Dakota Electric has opt-in, and we do set the rate for Dakota Electric customers because of the statutory opt-in. But there is no opt-in here. Your leadership, your folks that you've elected, have continued to set the rates. And so I'm still not seeing how this rate dispute is somehow now a service dispute.
All right.
Can I jump in?
Commissioner Partridge.
Thank you, Chair Sullivan. I have a question for Renville. Mr. Alter, do you have a mandatory arbitration clause in your bylaws, or are you going to allow for mediation?
Mr. Alter.
Thank you, Commissioner Partridge. Renville Sibley adopted new bylaws in, I believe, 2025 that includes a provision allowing either party to request arbitration. Arbitration is not mandatory, and Renville Sibley is not going to mandate arbitration at any point prior to mediation. Renville Sibley's position since the start of this dispute has been that mediation is a proper next step to resolve the dispute between the parties.
Okay, and will mediation cost Mr. Rauenhorst any money to do? Are you going to charge him to participate in mediation?
Commissioner Partridge, my understanding is that both parties interpret the statute to require Mr. Rauenhorst to pay 10% of mediation costs, and the cogeneration rules of the cooperative include that required provision under the statute. So that's my understanding of the cost split between the parties in the event mediation moves forward.
Okay, but nothing beyond the 10% required in statute? Because the reason I'm asking you is that what Mr. Rauenhorst has said is that it would cost him quite a bit to go to arbitration, and so I want to make sure that that's not something you are requiring for him to continue to pursue this complaint.
Mr. Alter.
Thank you, Commissioner Partridge. That's correct.
Okay.
Mediation is our proposed next step. We will follow the statute in terms of the cost split as to mediation.
Okay, so I continue to think that we do not have jurisdiction. I think that the project sounds really innovative, very important, and I fully support the work that you are doing. I hope that you all can work together to come to an agreement on an appropriate rate, and if you cannot, I am sure that district court will solve it for you. I am sorry that we do not have jurisdiction, as I know that parties would like for us to take this on, but we do not. And we can go down different paths today on the substance of the complaint, but at the end of the day, if it is outside of our jurisdiction, it is just not worth your time to do that. I think you need to make those arguments in district court, and I am certain that the court will decide this in a fair way. If you're able to come to an agreeable rate through mediation, it sounds like that would be a great outcome. Again, this is an important project. It is important that we are able to learn about how we can integrate our energy resources with our agricultural practices and businesses in Minnesota. So I hope that Renville Sibley sees the value in that. I hope that you all are able to mediate this and come to an agreement, and if not, I hope you continue to pursue your complaint in district court. I'm ready to make a motion unless anyone else has comments.
I mean, I'm the chair right now, so you can have, what do you want to say?
Thanks. I just had one question, and then a quick comment. In what capacity did you work on these rules? You said you were.
In what capacity did it?
Yeah, you're representing an interest, or?
I would have preferred that we discuss this at earlier when we introduced it.
But
It actually,
Commissioner Sullivan, I need to take a break. Let's just take a 5-minute break and then we'll come back and proceed with the remainder of that question. But I'm a little uncomfortable. Normally, people who are in front of us don't ask the commissioners direct questions. So I'd like to take a break, at least until 11, please.
okay. We'll be in recess till 11. Are we ready? Okay, well, thanks. The commission will come back from its recess. After talking to council and reflecting on this, my plan will be to abstain from the vote. So with that, I do not, I've thought about this. I have talked to council about it. And in looking over our rules, I did not have, and I do not have a conflict of interest on this matter. But it is my view that it is important for the appearance of the parties that I abstain. So that's what I'll be doing. So I'm going to hand the gavel over to Chair Sieben, and she can finish up the meeting.
Thank you, Commissioner Sullivan. And just to be clear, I think that while there have been a lot of much discussion today about the actual complaint that's before us, the overall position that I have is similar to what I came into the hearing with, is that the commission doesn't have jurisdiction over the actual complaint today. So Commissioner Partridge, if you're ready, or if there aren't further questions, I think we should just move decision option 1 and find that we don't have jurisdiction over this matter and dismiss it. And sir, I'm sorry, but it's not, I'm not going to call on you right now.
Madam Chair, I would like a point of clarification.
Okay, but I'm running the meeting right now, and I'm trying to say that the commission right now, my perception of the complaint that has been brought to us, which is your brother's complaint, and you also, as we have stated and is shown in the record, and as the Department of Commerce's attorneys have argued, the commission doesn't have jurisdiction over your complaint. So I'll give you a chance to speak with the understanding that then we are going to proceed to vote. Commissioner Sullivan is recusing himself from the vote, but there are still 3 commissioners who are prepared to take a vote when it's time. So, Mr. Rauenhorst, and apologies, I can't pronounce your last name correctly. What would you like to say to the commission before we vote?
Thank you, Madam Chair. Point of clarification. If we do the mediation and it fails, will Renville Sibley, do I understand that Renville Sibley will not pursue mandatory arbitration, and then we will go to district court to settle this matter about?
You'll have to talk to your attorney about that, sir. All what the commission is saying is that it's not up for us to decide how to resolve the dispute between the co-op and yourselves.
But they have not been clear as to whether or not they are going to mandate on their side that we go to arbitration.
Okay, I appreciate your perspective, but that's not something that we're going to be able to resolve for you today. And it's not up to the commission to resolve that issue either. My understanding is you have filed a case with district court, and so I assume, based on the discussions that happened earlier, if you're not successful with arbitration or mediation, then your lawsuit will continue at the district court, but it's not for us to decide what the resolution of that matter is. So, Mr. King, I don't know what you'd like to say right now, but you can have another minute to address the commission if you'd like on the matter before us, which is whether we have jurisdiction over the matter.
Thank you, Commissioner Sieben, and I apologize, Commissioner Sullivan, for incorrectly not identifying who's chair. It's just speaking to the issue of jurisdiction. The statute says, for the purpose of this section, the term commission means the board of directors of a cooperative association that elects by resolution to assume the authority delegated to the PUC over cooperative electric associations under this section, and adopts and has in effect rules implementing this section. The Renville Co-op no longer has rules in effect implementing this section because they are not paying the appropriate rate for net meter facilities, which is in this section. They do have adopted a binding arbitration clause that is in violation of this section. And also, they're not allowing people to net meter if they have 2 meters within a mile, which is in violation of this section. So in my reading of this, you would have authority because we gave them the extraordinary right to self-regulate as a utility, provided they meet the
Mr.
standards,
King.
and they don't. Okay, that's just my comment.
Just a second, commissioners. I appreciate that Mr. King thinks that he wants a third shot at making his case to the commission. I would direct parties to the written testimony that has been submitted by all of the parties into this item today, or into this docket today. And it feels a little bit like this is getting performative, and I would just like to end it now by asking commissioners if they have any further discussion on Commissioner Partridge's motion to move decision option 1. Is that your motion, Commissioner Partridge?
That is my motion. I have no discussion further.
Again, Commissioner Tuma, anything further?
I've got the whole record. I read it. Pretty clear to me.
Great. Thank you. All in favor of Commissioner Partridge's motion to find that the Minnesota PUC does not have jurisdiction over this matter and dismiss the complaint, please say aye.
Aye.
Aye. Opposed, the motion prevails. Thank you, everybody. I hope you have a good rest of your day. The meeting is adjourned.